Hello. A common question people want to know the answer to is, what is mediation? And why will my Florida personal injury case likely end up there if I'm injured in Florida? My name is Robert Gluck, and I am a trial lawyer for the past 32 years, and I have offices in Naples and Plantation. I handle cases involving mediation every day. Anytime you're injured in Florida, you have an opportunity to present a demand for settlement to the insurance company for the party that's at fault or responsible for your injury. Usually you'll have a lawyer to do that for you. If the parties are not able to reach an agreement and your lawyer is not able to get your case settled with the insurance adjuster, then a lawsuit would be filed. In Florida, every judge in every county is going to require a case to go to mediation before you can go to trial. So the Florida Constitution gives everyone their right to a trial. You have a right to access to the courts. It's a constitutionally protected right in Florida. But that does not mean that that's the exclusive remedy or that the judge cannot put up hurdles or requirements that you have to comply with before you can get to trial. So one of the things that almost every circuit court judge and many county court judges require is mediation. Why? Because mediation is an informal process where each party gets to sit around a table with the folks that are available and are necessary to make the financial decisions. In other words, if you're suing somebody that has insurance coverage, the insurance company's lawyers and their adjuster needs to be at the mediation. If you're injured, your lawyer needs to be at the mediation. And then a mediator, which is kind of like a judge, except he doesn't make any rulings, and nothing that he says is binding on the parties. But what the mediator does, as usually an experienced retired trial lawyer, they kind of help the sides get closer. They listen to each side make their arguments as to why they think they're entitled to whatever they're entitled to. Your injury lawyer will make a claim as to why you're entitled to a certain amount of money, what permanent injuries you might have, whether you have non-economic damages, whether you have damages that will go on into the future, what your life expectancy is, how permanent or how serious the injury is, whether it's left permanent scarring. So your lawyer is going to make arguments as to why your case is worth more money. And then the insurance company is going to have their lawyer make arguments as to why it should be worth less. So each side explains to the mediator why they think they're right. And then the mediator at one point will separate the two parties into separate rooms and kind of go up and back between them, trying to get you to lower your demand and trying to get them to increase their offer. And then they go up and back and up and back, and some of these mediations take hours and hours. Ultimately, most of the cases settle at mediation. But you're not required to do that. If they don't make a fair offer, you and your lawyer can pick up and walk out the door and say, we want our day in court and we want to have a trial. But a mediation is quicker, it's cheaper, it's an immediate outcome, there's no appeals, and you usually get a check within 2 weeks. So if you have a case that needs to go to mediation, or if you want a second opinion on your case, call me.